Good morning friends, सत श्री अकाल, आदाब। आज जो 80th video of mine is being made and we've been discussing अभी पीछे my video, this is in continuation to that only, that what is the status of various cantonment bungalow owners, whether on lease or OGBs. So we in the earlier part had discussed there are 4 kinds of bungalows which are either in possession of the HOR or in the possession of the hiring factors of the MES or army, or they are in possession of tenants for the last 40-50 years, they are dilapidated, and somewhere it's in the occupation of an HOR, but he is not the legal HOR. So in this case we will be talking of the dilapidated bungalows which are standing. Now in this case again we have 4 happenings. It may be an original HOR, it may not be an original HOR, okay. Maybe part of the bungalow is dilapidated, maybe part of the bungalow or the outhouses are being maintained. So there could be a lot of questions. This even dilapidated bungalow could be for the reason because it was on hire with the army. Army was not maintaining the lease because it was paying a very meager amount of rent and they let the bungalow fall. So what do we do? Lot many bungalow owners call me up for this. Dasa, what should we do on this? And then, guiding them on the telephone instantly without knowing much about the property is not very easy. And the expectation I can imagine is very high of the resident up there. Because he's walked into me through a YouTube or through somebody that Mr. Das is quite knowledgeable and is doing a lot of effort. No, I am the same person like you. My knowledge is only grown because I am learning. And even today I am learning. I am studying. I give myself many hours to the various judgments which I have started digging into now. So friends, what should be the biggest question for this OGB or a lessee who's now owning a bungalow which is dilapidated? So in this question, is that HOR entered in the GLR? That's very important. Or is he that HOR which has inherited that property from the original HOR? Or is he an illegal buyer HOR? And he purposely bought a dilapidated property. So let's go by what does that GLR speaks on. Immediately he should or she should approach the DEO and ask for a sanction of building plan. If it is dilapidated, neither in possession of the army. And under which policy? That's the 1995. You have to sign various documents, admission deeds, and this policy and this approval coming is not very easy. It is very scanty in cantonments and very sub judice to people who are, at a different platter or are from the army itself. I have come across a lot of cases where DOs, PDs, DGs or Commander-in-Chiefs have given permission. So those all can be shared so that you can make a precedent, but I'll make sure about it. In Pune, when some bungalows were converted into freehold, they had gone for a plan approval with the Commander-in-Chief, which was rejected. Unfortunately, the Supreme Court also struck down the approval of plans on very simple 2 words called may or shall. May, the second word was shall. So these were the 2 words which were used, which does not bind the Commander-in-Chief that he has to give you a approval. He can reject it. So now, what do we do? Second, the HOR should approach the DO or the local military authority, get it resumed. Under the 1970 resumption policy, get it voluntarily resumed. But a $1 million question. Before you initiate this, please get in touch with me, because we now will be moving on a different platter which most of the Sandys and Paddies and the Surnis have been complaining against me, which Mr. late Gopal Narayan ji had stated to me. that they think that I am only looking for compensation. No, even that doesn't flow so easily. So to get a better compensation, please get in touch with me. I'll make sure what are your documents, what are your building plans, and there are so many things which need to be dug in before we finally go into the department for resumption. Third, we can table if the possession can be asked. So if the possession is already there, then we can move an application under 144 to the CO to give us a permission for repair. If not that, I'll be very honest, Mera Desh Mahan, we can get it done the other way around. So I will share those where the Commander-in-Chief has given compounding orders on various bungalows which have been risen from scratch by illegal HORs. Even today it is standing in the name of Chopras, and the bungalow has been reconstructed. Cases all over I have. So we can take them as reference if need be, and if not be also, we can always put them across the table and ask for a repair permission. The similar doing is to be done by an HOR, not original but an inheritor, not in the GLR records, mutation, and then further under the 1993 MOD letter of inheritance, he should ask for his plan approval. Because plan approvals will only take place in the name of HOR if he is in the GLR. Otherwise, you will have to move under the repair permission. And that also, how the repair permission? I'll just share it. Now, this is that repair permission where an illegal occupier is there now in the bungalow. It's not very easy. But the world doesn't end here. So we can get those kind of permissions. But how do we get them? SK Bose has given a report. There are many sales which have happened, not been mutated for various reasons. Somewhere. So more than about 1,000 cases are pending like this. All open eyes. Everybody knows. So what is the solution now for this illegal HOR to get his? Let's go by the way Sandys and Paddies have gone through. They've moved applications in the original name of the HOR by his signatures, and they've asked for permissions under repairs. So the old HOR is getting a repair permission, and the whole bungalow has been renovated like a villa of today's. I have a case where 1.25 lakh compounding fees the Commander-in-Chief debited. Willingly the bungalow owner or the HOR paid, whether illegal or not. So we all need to get in touch with each other at the right time, at the right evidence. Everything can move rightly. Nobody is against us. When the HOR is in occupancy, he should definitely move and ask for the first thing what I say is mutation. If not that, come to me for tax purpose mutation. I'll make sure the predecessor's name is removed and his name is left alone in that bracketed column there. What the tax superintendent for the last 10 years or 20 years has been doing. In the name of Wing Commander so-and-so, bracketed so-and-so. So, everything is to be done in a very simplified manner, but with an approach where you know your rights. So, that is why I say that you need to get educated. Because I know these mutations and how these occupancy rights get disturbed, jeopardized when finally, because if a dilapidated bungalow is in possession of the army, or is in the hire of the army, it will resume your bungalow. It doesn't give you the rights of compensation. So we need to get all these things done in a very chronological manner. So friends, I just told you how sales have to be taken, how sale agreement, special power of attorneys, journal power of attorneys, will of the HOR, how relinquishment deed of the HOR's family members has to be taken. So let's get into all this. It's not a very big subject. We can very easily, under these dilapidated bungalows, look in for these two directions, either resumption or whether possession and repair permission or approval of plans. So get doing it, get in touch with me, and I request you to please subscribe my YouTube channel, which is very important. I would be grateful if you people can make not just you, but even your neighbor or within your family, any amount of numbers, subscribe the YouTube channel. And my last statement, that we were always old grants. We were never converted into new grants by the Britishers, by the original orders of regulations of 1790 or 1793 till last 1859 regulation. So that is why we are revenue free grants, even till date written in our GLR, what? Old grant. Thank you. Good day.